Welcome to the other side of Lucy Letby, and in episode 57 we're going to continue with this analysis of the Court of Appeal ruling against Lucy Letby, denying her the right to appeal. And we're roughly around about paragraph 114, and we have accepted that Dr. Evans is suitably qualified to give an opinion. And let's just accept that, because, as I say, it's appeal to authority or ad hominem in a logical argument to attack the witness rather than what the witness says. And we're not interested in that. And then there was the focus on Evans as an investigator as well as a witness or expert witness. And I think the judges completely misunderstand what's going on here. Judges are clearly wrong that Evans simply played a role as an investigator. That's bad enough. But what Evans actually did was he created the offences. And in order to create the offences, he had to set aside the gold standard findings of postmortems. And no method that Dowie Evans would use to determine a cause of death could be better than that gold standard method. As with all the other experts, Dr. Marnarini's using histology to prove the presence of an neuroembolism, not an accepted method, and Professor Owens using postmortem x-rays, not an accepted method. And that the failure to stick to accepted methods goes against the content, or at least the spirit, of paragraph 7 of the Criminal Practice Direction 2023. Which requires that you use a recognized method as an expert and that you describe that recognized method. And we jump to 119 paragraph just to make sure that we're on the same page. When the judge refers to paragraph 711 of the Criminal Procedures Rules 2023, it was material, as the judge pointed out, that Dr. Evans' expert report was given in ignorance of other potentially incriminating material relied on in the trial. And let's just remind ourselves what these rules are. In relation to expert witnesses, Rule 7.1, admissibility generally. Expert opinion evidence is admissible in criminal proceedings if, in summary, it is relevant to a matter in issue at the proceedings. Yes, it was. B, it needed to provide the court with information likely to be outside the court's own knowledge and experience. Yes, it was. But that line should read, it is needed to provide accurate information to the court. The witness is competent to give that opinion. Yes, the witness is competent. And D, the expert opinion is sufficiently reliable to be admitted. And I argued that Dowie Evans' evidence and all the rest of the expert evidence was a million miles away from that. And it carries on the extent and quality of the data on which the expert opinion is based, very poor. The validity of the methodology employed by the expert, non-existent. Cause of death by diagnosis of exclusion is not a thing, as people would say nowadays, and is a million miles away from postmortem findings. If the expert opinion relies on an inference of any findings, which Dowie Evans does, whether the opinion properly explains how safe or unsafe the inference is. And that's a big problem with Dowie Evans' evidence. It doesn't rely on any method, rather it sets aside the well-established methods of reaching conclusions on the cause and mechanism of death. Continues whether the expert opinion relies on the results of the use of any method. Well, it didn't, but even if it did, whether the opinion takes proper account of matters such as degree of precision or margin of uncertainty. Well, we have said there are 2 or 3 sources of error in the error emboli in all of these babies, which means that even if an error embolism was present, there is no degree of certainty or precision to determine where that error came from, either as a cause of collapse or as a consequence of the medical interventions carried out after the collapse. All of the diagnoses of error emboli were made solely by Dowie Evans retrospectively and not contemporaneously, making it impossible to determine where any error came from. The extent to which any material upon which the expert opinion is based has been reviewed by others with relevant expertise, for instance in peer-reviewed publications. No, Dowie Evans did not use any peer-reviewed publications to reach a diagnosis of exclusion for her emboli. It is solely the opinion of Dowie Evans, and a finding of consistent with is too low a standard by which to make clinical decisions, and so cannot be used as evidence of a crime. Now, we've covered all this before, but just to put it into context, the main one is that an opinion should not be based on a hypothesis which has not been subject to sufficient scrutiny, and that would be the entirety of Dowie Evans' evidence. Based on an unjustifiable assumption, justification being another word for scientific proof, and it just carries on endlessly, so we'll leave you a link to all of that. In paragraph 119, they talk about the bona fides of the other expert witnesses, which is, again, I say irrelevant. It's not who they are, it's what they say. And then in paragraph 120, the judges make a rather bizarre claim as far as I'm concerned. They say, we have carefully considered the particular examples of Dr. Evans' conduct relied on in the perfected grounds of appeal and the prosecution answer to them. We have done so by reference to extracts from the transcripts to which we were specifically directed, but in the context of the vast volume of other material, including the transcripts of the evidence, we have read for the purposes of this application more generally. I have no idea what they read. In the event, we have no doubt that all of the criticisms of Dr. Evans, including those made by reference to the observations of Jackson L.J. in a different case, were capable of being dealt with within the trial process, or that the judge was fully entitled to conclude that ultimately, as with any other witness, it was for the jury to assess Dr. Evans' reliability, having regard to all the evidence in the case, with the assistance of comment and submissions from counsel on each side. By the same token, there is no arguable basis for interfering with the judge's exercise of his discretion not to exclude the evidence of Dr. Evans under Section 78 of PACE. And again, I'll leave you references to these, Section 78 and Section 76, and I'll leave you a link to that. But it's about confessions and the balance of probabilities. Now, let's look at the balance of probabilities. In the current version of Lee and Tanswell, the updated version, they describe 117 cases of emboli, all arising as complications of intensive care treatment in preterm babies. Only 2 of the 117 cases reported worldwide describe this pink flitting rash, which they refer to as the Lee sign. So I asked you, what is the probability that the Lee sign would make an appearance 7 times in 1 year in the Countess of Chester Hospital when it's only made an appearance by 1 person in the entire history of medicine? I don't think you need to do any calculations to see that the probability of that is extremely low. So if I were Mark MacDonald, I would be working very hard on the admissibility of this bullshit evidence. The American writer Mark Twain, amongst others, used the following phrase to describe a gold mine. He said it was a big hole in the ground with a liar at the top. You can make your mind up. What I think about the comparison between this evidence and the gold mine, as Mark Twain might see it. Anyway, after all of that, of course, the appeal court judges find that there are no arguable grounds for appeal on the integrity or admissibility or veracity of any of the pseudoscience used to make retrospective diagnoses of emboli. I can see that the notion is so laughable from an evidentiary point of view. And as I've said before, if we all practice medicine like this, it would be utter chaos. And in 122, they carry on. We should note finally that after the judge's ruling of the 10th of January 2023, Dr. Evans was asked about the observations of Jackson L.J. in cross-examination. The effect of Dr. Evans' evidence, as we summarise, was that the criticisms made in the decision were based on a false premise. This is the opinion of Justice Jackson, that Evans is an unreliable witness. We'll let the judges finish here. So they say a false premise. The report, that's the report that Justice Jackson referred to, that Dowie Evans constructed for a solicitor, these judges say was based on a false premise. They say that the report was not an expert report prepared for the court or a witness statement. Rather, it was a letter to the solicitors in the Kerr case. And why the hell does that matter to anything? It's an unprofessional letter from an unprofessional doctor, no matter what the circumstances. And they carry on that it had been used by the solicitors for the purposes of the application for permission to appeal without his knowledge or consent. We only need to know one fact about this letter, which we don't know, but which should be easy to obtain. Did Dowie Evans receive any payment for the letter? And if he did, he no longer has a right to determine where and when it's used. And it's a professional report because it came about by the result of a commercial transaction. I have done a lot of pro bono work in my life, writing expert reports, mostly for refugees. And by refugees, I mean people who were seriously damaged because of war or civil unrest in their home country and who were being forced back into that situation by the Irish state unlawfully in the cases that I worked with. I supplied these reports to many solicitors and volunteer organisations because the victim of the war didn't have the resources to get the reports themselves. All of them were my patient by default, and I considered this part of my duty as a doctor. But once I had written those reports, I did not and could not assume control over where those reports went to, and I didn't need to. All I had to be sure was that everything I put in those reports was based on my findings and observations, history taking, and verification by other people if that was possible, and that I believed that everything that I wrote in the report was true to the best of my knowledge. That was a professional report for which I could never be civilly or criminally liable, nor subject to any complaint by the judiciary or government department. And none of my reports were ever subject to such a complaint. But we need to look back a little bit at the complaint made by Jackson L.J. to see that this is again a mistake, in my opinion, by the appeal court judges. Because I see the report that Jackson L.J. wrote as a two-part report. One part refers to the content of the letter itself, and another part of the report refers specifically to the writer of the report. And let's just look at what I mean by that. Jackson L.J. said, finally, and of greatest concern, Dr. Evans, that is the person, Dr. Evans, makes no effort to provide a balanced opinion. He either knows what his professional colleagues have concluded and disregarded it, or he has not taken steps to inform himself of their views. Either approach amounts to a breach of proper professional conduct. No attempt has been made to engage with the full range of medical information or the powerful contradictory indicators. That is not a description of the letter, nor is it a false premise. It's a description of the writer of the letter. Instead, the report has the hallmarks of an exercise working out an explanation That is a description of the letter that may be based on a false premise, but the judge didn't think so. And then they go on to say, it ends. So the letter ends with tendacious and partisan expression of opinion that are outside of Dr. Evans' professional competence and have no place in a reputable expert report. So there are clear references to he, and there are clear references to it. And I can tell you, had Justice Jackson written that letter to the Medical Council, either in the UK or in Ireland, they would have come down like a ton of bricks on Darry Evans. But in this appeal hearing, he is washed clean of all his sins, baptized and reborn as a wholly reliable character. And paragraph 122 finishes off, poor old Dr. Darry. Further, he had not known of the decision, that's L.J. Jackson's decision, before it was brought to his attention by the prosecution. Everyone in this trial, i.e. that of the applicant, had seen the decision before he did. And again, I ask, why is that relevant to anything? Dr. Evans wasn't on trial. He was a witness in the trial. And they carry on. Ground 2, the submission of no case to answer. And they say there is a degree of overlap between ground 2, challenging the judge's direction that the jury did not have to be sure as to the precise harmful act or acts committed by the applicant against a particular baby. It is nevertheless convenient to consider them separately. The submission of no case to answer was aimed at counts 1, 2, 4 and 16, in which the prosecution alleged that our embolus was the sole cause of the death or collapse of the child concerned. And counts 3, 5, 12, 17 and 20, cases in which the prosecution alleged that our embolus was a cause, in addition to other causes, of the death or collapse. The applicant relied upon R versus Galbraith, 1981, and in particular upon the second limb of the test stated by Lord Lane, CJ, in the familiar passage at page 127. So let's look at counts 1, 2, 4 and 16 first. That's baby A, baby B, baby D and baby M were attacked by Letby in a way that resulted in the creation of an embolism. And for that presumption, there is zero scientific or medical proof. And the hypotheses of the expert witnesses were obtained or created from belief and not method. And therefore, the content of their reports is not based on scientific reasoning and method, but is simply an opinion. And it's an opinion that runs contrary to the gold standard findings of the postmortems. Death by natural causes. In the case of baby A, unascertained cause, not at all unusual in preterm babies. Baby B didn't die, of course, but had multiple desaturations, which are extremely common, almost universal in these types of babies, and who was resuscitated via bag and mask. The collapse was caused by apnea of prematurity, which resulted in the physiological skin changes and responded to resuscitation, in the process of which it altered the skin discolorations and filled the baby's belly with air, as is nearly always the case with bag and mask resuscitation. Baby D died from pneumonia with acute lung injury. Pneumonia is a naturally occurring infection which is quite common in preterm neonates or in babies who have had prolonged rupture of membranes and not covered by antibiotics, in other words, baby D. And acute lung injury is caused by a catastrophic inflammatory response to that natural infection. That's what the postmortem found by the gold standard method, which we cannot alter by a substandard method. And finally, baby M, whose cause of death was widespread hypoxic brain damage that occurred over a prolonged period of time. And that prolonged period of time should be relatively easy to date by reference to the histology of this hypoxic damage to the brain, because at different stages of the baby's life, that damage is going to occur in different parts of the baby's brain. None of these cases could or should ever be considered to have died by any other means, and in a civilized country they wouldn't. And counts 3, 5, 12, 17 and 20 were babies C, who died from pneumonia, sepsis and extreme intrauterine growth restriction. Again, very common findings in preterm neonates who die. Baby E, who bled to death by an unknown mechanism because there was no post-mortem, but who had woefully substandard treatment during his life. Baby I, Baby M and Baby O had natural causes of death, as established by a much more precise mechanism: autopsy and case review, multiple case review. This whole trial comes down to Dowie Evans' opinion versus all of that. And then they get on to talk about this Galbraith test, which is the legal to determine if evidence is submissible in a criminal trial. Expert evidence. And this thing reads like this. 1. If there is no evidence that a crime alleged has been committed by the defendant, there is no difficulty. Well, I would argue in this case that there is no evidence. And they say that if that's the case, the judges will stop the case. So obviously, because the case went ahead, there must be evidence. 2. The difficulty arises where there is some evidence, but it is of a tenuous character. For example, because of inherent weakness or vagueness, or because it is inconsistent with other evidence. Now, we have to look at all of those words. Tenuous. A tenuous claim in medicine would be that a finding was consistent with a disease, because unless it's uniquely consistent with that disease and not found for random reasons during an examination of all of the medical evidence in the case, and in that regard, findings of gas in post-mortem x-rays would fit tenuous, inherently weak, and vague. These findings are not of any use to anyone, because we find these things all the time, and it's well established in the literature that post-mortem gas accumulation is a common phenomena. And it's also established in the literature that cardiopulmonary resuscitation is one of the main causes of this gas accumulation, occurring in 89% babies who undergo CPR, making it even more tenuous. And the same would apply to the histology diagnosis of our embolism. So I don't care what Dowie Evans says or anybody else says, this is inherently weak evidence for anything in medicine. Now, whether or not it's inconsistent with other evidence, to me, under this ruling, is unimportant if the evidence is vague, weak, or tenuous. And then it goes on to say that where the judge concludes that the prosecution evidence taken at its highest is such that a jury properly directed could not properly convict on it, it is his duty, or her duty, the judge's duty, on a submission being made. But if we take the phrase evidence at its highest, evidence cannot be taken at its highest if it isn't given at its highest. That just makes sense. And the evidence given in the Lucy Letby case from a medical, expert, scientific perspective is useless because it does not use any methodology well studied in medicine to create the foundation or basis of its conclusions. And then they go on in section B of this Galbraith test, where, however, the prosecution evidence is such that its strength or weakness depends on the view to be taken of a witness's reliability or other matters which are, generally speaking, within the province of the jury, and where, on one possible view of the facts, there is evidence on which the jury could properly come to the conclusion that the defendant is guilty, then the judge should allow the matter to be tried by the jury. In this instance, we go back to this circular logic again. We have criminal procedures rules which set down the standard of any evidence. And if that standard isn't met, the evidence can't be admitted or adduced, as these people say. That's the base case against the finding of guilt in the Lucy Letby case. The evidence isn't scientific. It's pseudo-scientific junk science, and therefore it should not have been admitted. And if a judge was going to admit it, it should have been admitted alongside the findings of the postmortems and all of the reviews of the other doctors who looked into these cases, and against the background and circumstance of the RCPCH report. That puts the evidence at its highest. Simply taking a now retired paediatrician who was never a neonate, who never worked on a modern level 3 neonatal unit, and saying that's good enough for a jury to consider defeats the whole purpose of the rules of procedure. And the phrase, "were on one possible view of the facts, there is evidence on which the jury could properly come to the conclusion that the defendant is guilty." That can only be fairly assessed by a jury if it set aside all of the other possibilities that may lead the jury to the opposite decision. The judge is not saying here, to my ears anyway, that there only needs to be one theory that the jury can decide upon. Because if you admit the evidence at its highest, particularly in medicine, you're going to have a range of possibilities to explain it. And then you have to reach for the methodologies of discerning those different explanations and coming up with the likely conclusion or the determination that you cannot likely conclude any finding from the paltry evidence that you've got, which is not an unusual circumstance in medicine. So in my opinion, Justice Goss has given a very wide interpretation of this Galbraith rule. And then in paragraph 125, the starting point for Mr. Myers' submission to the judge was the expert medical evidence was fundamental to each of the allegations in those counts. It was then argued that the expert evidence relied on the prosecution in relation to our embolus was insufficient for the following three reasons. 126. First, it was submitted that the scientific basis for our embolism is so weak that it fails to provide the level of reliability required to support those allegations. No, actually the opposite is true. We know at a very high level how our emboli come about, and particularly in what circumstances they come about and how they present. And if we set that beside that body of evidence, beside the evidence of these experts, the evidence of the experts is too weak to stand beside what we really know about our embolism. Mr. Myers argued that the underlying consistency, coherence and reliability of the scientific knowledge supporting the theory and diagnosis of our embolism did not provide a sufficiently clear and reliable basis on which to make a finding of our embolism. Fact is that our emboli have such a poor outcome, as do many other diseases in medicine, that there aren't many cases whereby people have had sufficient time to deploy diagnostic methods at the time, and most of the case studies and the knowledge of our embolism are retrospective case analysis, but they are robust enough to draw general conclusions from. The main one being that 90% of our embolisms in preterm neonates are a complication of mechanical ventilation. That simple fact alone means that it's possible for a preterm neonate on mechanical ventilation to develop an air embolism out of the blue and to create the signs and symptoms witnessed in the Letby babies, and to draw a differential that may have been the cause of death. And because 90% of these air emboli are created by complications of mechanical ventilation or central line, that is sufficient knowledge to say that those are the two likely sources of the air embolism. And therefore, if you find an air embolism, and that means the presentation as described by these experts, let's just accept that their presentation is that of an air embolism, then 90% of them are likely to come from the complications of mechanical ventilation or intravenous lines. And in order to convict Lucy Letby, you have to be able to set aside the 90% probability that one of those complications was the source of the embolism, which these witnesses singularly failed to do, collectively failed to do, and which the defence did not seize upon. It's my understanding that it's not the done thing to criticise the defence if you're a lawyer, but honestly, it happens in medicine all the time. And it's generally not difficult to find a doctor to give evidence against another doctor. And then paragraph 127, secondly, it was submitted that the available research relevant to air embolism was extremely limited. It did not meet the requirement of paragraph 19A5 of the Criminal Practice Direction, now replaced, as we have said, by the similar provision of paragraph 7 of the Criminal Practice Direction 2023, and it was insufficient to permit any expert evidence to be given. And immediately you have to say, what a stupid argument to make, because you've called an expert to the appeal court to give evidence as an expert on air embolism. And it is nonsense to say that there isn't enough knowledge about air embolism upon which to give evidence at its highest. The problem is that in this case, the evidence was not given at its highest, and that should have been the legal and medical argument. The judges carry on. In this regard, it was submitted that what was needed was evidence establishing a sufficiently reliable basis for the diagnosis of air embolism. Well, we have that. Doppler and transesophageal echocardiography. The argument should be that neither of these state-of-the-art methods were used to diagnose air embolism. The argument indeed is that even with the best methods of detection of air embolism, it is not easy. It's very challenging to say that you can find where the source of that air embolism is. That is the weakest part of the current knowledge of air embolism and the technological ability to detect it. And there are programs in place whereby practitioners who have seen air embolism, particularly in adults during surgical procedures, are trying out methods to detect it before it causes problems. So that's a dud argument from the defence. The judges carry on. It was not enough for the prosecution merely to show that they had produced the best evidence which was available on a topic which had not been the subject of much research. And again, that's the defence not knowing what they're talking about. There's a ton of research into air embolism. And one of the reasons for that is that air embolism is quite high on the list of complications for which hospitals are sued, particularly in the United States. And for the most part, insurance companies and Medicare, the American equivalent of public health in Europe, won't pay out for venous air embolism injuries anymore because they maintain that they're all avoidable. But remember, that's just for venous air embolism. On paragraph 128, thirdly, it was submitted that none of the expert witnesses who had given evidence as to the general theory or diagnosis of air embolism had sufficient clinical expertise to enable them to give expert evidence as to those matters. And again, that's just bullshit. It's not difficult for anyone who understands the language of medicine to make himself learned on the current state of knowledge of any topic in medicine. It may take a lot of time and a lot of personal research and the use of a medical dictionary, but it's the type of thing that many people do all the time. So another dud argument from the defence. In summary, it was argued, 1, Dr. Evans had no clinical experience of diagnosing our embolism. He relied primarily on the Lane-Tanswell paper, and he gave inconsistent evidence as to the characteristics of our emboli. Well, the judge's argument would probably be that our emboli present inconsistently, and therefore any description of them will be inconsistent. But that fact should have formed the basis not of the argument given here by Mr. Myers, but for the argument that in fact Dr. Evans' description of our embolism in these babies was too consistent, which is not typical of our embolism, except for the fact that 90% of them happen when there is mechanical ventilation in use. And two, Dr. Bowen had seen only one case of our embolism. She accepted that there was very, very little literature relating to our embolism in children, and she too gave inconsistent evidence, including as to skin discoloration, in relation to individual children. Well, these are not children, they're preterm babies. The defense is all over the show here again. Quite frankly, they don't know what they're talking about. And three, Professor Kinsey accepted that our embolism was not part of her expertise, and it was submitted that she was not able to call upon a reliable body of scientific knowledge to establish how our embolism in neonates presents by way of cutaneous features. Well, it doesn't present by way of cutaneous features. It presents by way of many features, 90% of which are the presence and activity of mechanical ventilation. So saw the cutaneous features. Cutaneous features are common to many diseases in medicine, but they're rarely the central pathology of the disease. Take rubella, for example, German measles, a very common disease in childhood around the world, with a very characteristic rash. But the characteristic rash can vary. But who cares? Because as long as we know it's rubella, the rash isn't of any particular importance. And the rash is not the part of the disease that causes the problems that arise from rubella. And four, Professor Arthur's opinion that a post-mortem finding of gas in a great vessel may, after excluding other possible explanations, be attributed to our embolism was not based on any clinical experience and relied upon his own insufficient review of cases. And the argument here was that there is no way of excluding other possible explanations, or what should have happened during the trial was to force all of these people, these experts, to describe the reliable method by which they excluded other possible explanations. And they don't have a method for that. And if they don't have a method for that, as I understand it, under these procedural rules, their evidence should have been inadmissible as expert evidence. And finally, Dr. Marnarides could not or would not explain the mechanism by which our embolism causes death in a neonate. But the mechanism by which our embolism causes death is not the issue. We know our embolism can cause death. Again, Mr. Myers should have stuck to the point of forcing these people to say how they knew where their embolism came from. What was their methodology for establishing that fact? Because they had no methodology for establishing that fact. And in 129, it was therefore submitted that even taken at its highest, the prosecution evidence that babies had died because of an embolism was not such that a jury properly directed could properly convict upon it. This is our Galbraith test. But that is not a feasible argument either. The argument, as I see it, is that the evidence wasn't given at its highest. And if it wasn't given at its highest, it cannot be taken at its highest. There is enough medicine and science to explain these mechanisms and how these things come about. The expert witnesses simply chose not to use that evidence, and the defense was not in a position to counter them by citing the multiple papers I've cited over the course of all of these podcasts and calling their own experts to call these guys bluff. And on the basis of that argument, the defence says that counts 1, 2, 4, 16 should therefore be withdrawn from the jury, and in relation to counts 3, 5, 12, 17 and 20, the jury should be directed to disregard the evidence of air embolism as a cause of death or collapse for those babies. Again, no. Air embolism quite reasonably may have been the cause of death in those babies. But the expert witnesses, and I repeat it again, did not make the point that it was nigh on impossible for them to say from which complication did the air embolism arise. And therefore there was no way of knowing if venous air embolism was the cause of death or pulmonary vascular air embolism was the cause of death. And in fact, Myers could have went one further and said, you are only talking about pulmonary vascular air embolism because the only paper that you've cited endlessly in this case is about pulmonary vascular air embolism and not about venous air embolism. Paragraph 130, the prosecution opposed the submission of no case to answer, arguing that the expert evidence as to air embolism was properly admissible. And I would agree with that, but I would not agree that it was given at its highest. The prosecution say it was not evidence from the fringes of science, and I would disagree with that. In general, the science or medicine around air embolism is not fringe, but the version of it given by these experts is definitely fringe. None of the papers that Dowie Evans used in his minimalist 19-paper presentation or review would dare to claim that air embolism can be diagnosed retrospectively without any reference to a proper method for doing so. And the prosecution continued to argue that the evidence did not have to be given by someone who may be described as an expert in air embolism, a status which, it was suggested, it would be difficult if not impossible to attain. Not true. It's possible to attain expert knowledge on any topic in medicine so that you could be the go-to man and indeed spend your entire life studying air embolism. So I don't agree with the prosecution on that summation. It was further submitted, this paragraph goes on, that the concept of air embolism is widely recognized in medicine. Of course it is. That a number of witnesses had given evidence that great care was invariably taken in clinical practice to avoid air passing into patients' circulations. Bravo! Well done. Hats off to all the people in the Countess of Chester Hospital. That still leaves 9 out of 10, at least, air embolism sources as mechanical ventilation and cardiopulmonary resuscitation. And the air embolism that arises from those is not preventable because it occurs due to the immaturity of the babies themselves, which is not avoidable, and in fact is generally mandatory to be present in the place, a neonatal unit, where most of these air emboli are found. And that should have been part of the defence summing up. It was therefore submitted, as we carry on with this paragraph, that the arguments on behalf of the applicant went to the weight of the evidence rather than its admissibility. The respondent emphasized the importance of the jury considering the totality of the evidence about a particular baby, including the expert evidence that the baby's death or collapse could not be explained by natural causes or any other non-criminal cause. And for me, this is the killer line for the defense failure. During every one of the cross-examinations of these so-called experts, the defense should have had on their desk the autopsy report and read it out line by line, asking the experts to explain each line, either generally or with reference to their own specialty, and particularly with the emphasis on methodology. Junk all the observational skin discolorations and all that crap. Go to the method, because the law requires that these experts use a recognized method to reach their conclusions, and in my opinion, they did not. That should have been the strategy for the defense in this case, which would have allowed the defense to sum up honestly to the jury that, particularly in the case of air embolism, which is what we're talking about at the minute, there's no way in God's earth they could be sure where it came from, because each of these expert evidence witnesses would have had to say that. They could not have avoided saying that, no matter how hard they tried to bluff their way through it. Mr. Myers' argument should have been, let's return to methodology. By what method do you draw that conclusion? Is diagnosis by exclusion a common technique for diagnosis nowadays? And when they start to bluff, go back to the postmortem findings. Call one neonatologist and ask them to explain to the jury why prematurity itself is a sufficient diagnosis to explain death in these little babies. Remember, 2 to 3 to 4 per 1,000 babies die in the UK as early neonatal deaths, but between 150 and 200 per 1,000, depending on the gestation, of preterm babies die in Britain, meaning that from prematurity alone, the death rate amongst preterm babies is 50 or more times higher than for term babies. Now, if we translated that same fact into road traffic accidents, we would jump overnight from 2,000 deaths per year to 100,000 deaths per year, just for getting into your car and going somewhere. So for the prosecution to say that any of these babies' deaths could not be explained by natural causes or any other non-criminal cause should have been argued in the court as a ridiculous statement. So we'll halt here at 131, paragraph 131, because it is ground 2, the judge's ruling on the submission of no case to answer. Now, I think there was no case to answer, but the place to establish that was not in the court. It was before the court proceedings started. Lucy Letby started out her legal journey with the on-call solicitor and not a specialist criminal defense solicitor. She then ended up with Ben Myers, who, in my opinion, allowed himself to be pushed around by the prosecution without objecting to practically everything they did. And lastly, he didn't put any experts in to counter anything that the prosecution experts, who are not supposed to be prosecution experts, said. Now, there's a little bit of confusion about that, because it seems that in a pre-trial hearing before the jury came in, the defense wanted to put their experts in at a particular time. They wanted their experts to run concurrent with the prosecution experts, as I understand it, so that the jury would hear two sides of the argument at the same time. And the prosecution objected to this, and the judge sided with the prosecution, and Ben Myers should have told the judge, which again, it's my understanding that he was perfectly entitled to do, that he did not agree with the judge's approach. And as a consequence of that ruling by the judge, it seems as if Mr. Myers moved from that strategy to a strategy of not using his experts at all, which is inexplicable. And it's inexplicable all the more because the jury didn't find Lucy Letby guilty of everything she was accused of. But they did go for a full house on the air embolism cases. which, in my opinion, should have been the easiest ones to knock out of the park. Mr. Myers didn't spend enough time talking about methodology, science, medical procedure, how diagnoses are reached, the importance of the differential diagnosis, and why no diagnosis is complete without a significant differential. And to finish off this podcast, I'll tell you a couple of stories from my life that demonstrate why process and procedure and method are just as important in medicine, if not more so, than they are in law. I was once a registrar in a local general hospital, and that pretty much meant that at night time I was the guy on call for medicine and for pediatrics. Because this hospital didn't have an obstetric unit per se, I never in that capacity had to do any neonatal medicine during that period, not even someone turning up at A&E. But I remember it was a lovely summer's evening, and I was sitting at the nursing station on the ward, writing up notes, chatting to the nurses, as we Irish would say, having a crack. But things can go pear-shaped in medicine in an instant. And that night, a mother brought a teenage child to A&E, and the good sense people in A&E immediately wheeled the child or the young adolescent around to the paediatric ward, which wasn't very far away. And at the same time, they rang the ward and told the ward that they had a case of meningococcal meningitis, which can be lethal and lethal very quickly. And one of the difficulties of diagnosing meningococcal meningitis, is that, like all other things in medicine, it has a differential. And what you're seeing in the patient and what you're hearing is an expression of the disease, as told through the history, observations and findings. But it was pretty obvious that this child had acute meningococcal meningitis with disseminated intravascular coagulation. And even though DIC, which at its simplest is disseminated, that's all over the body, intravascular within the vasculature of the body, coagulation, that's blood clotting. There are some things that can cause that aren't meningitis or meningococcal meningitis, but they are very rare, and you would be very unwise as a doctor in that scenario to assume anything other than meningococcal disease, which I did. And we started usual treatments for that, which was major resuscitation, and back then penicillin, which was incredibly effective against most infections. And meningococcus would have been one of the bacteria that the discovery and use of penicillin had a great effect on. The case fatality rate, that's the number of people who would die of an infection from meningococcus, was 60-70% and reduced to about 10 to 15% or even less by the use of penicillin. We worked on this child for a couple of hours until we were pretty sure that he was stable. But it was touch and go when we had to tell the parents that, as to whether he would live at all through the night, and if he did live, whether he would be severely damaged by this infection. And when this mother was on the phone to her sister to tell her about this, the sister told her that his cousin was also feeling unwell with a headache and vomiting. And the mother told a nurse, and the nurse told me. So despite the fact that I had asked the mother during the history to tell me where her son had been that day, she hadn't been able to tell me that the son, along with cousins and others, 6 kids in all, had bunked off school, and that they had been drinking, smoking and necking with each other as teenagers do throughout the day. I told the mother to bring her child in. And the child was reasonably well, but had symptoms of infection or prodrome, what we would call. Symptoms, non-specific, headache, vomiting, temperature a little bit, fast pulse. So after we'd taken the blood cultures and the lumbar spinal tap, I started the kid on penicillin. And even with the penicillin, within about an hour, this child began to develop DIC as well, which more or less confirmed to me that this kid also had meningitis. So that left the problem of the other 4 kids, and we managed to track them down over a few hours, and even in the middle of the night, telephoned them, got the police to go to them, and brought them into hospital. And over the course of that night and early morning, all of them developed signs of meningitis. And the outcome of this was very strange indeed. All but one of the kids survived without any adverse or long-term effects. And the kid that died was one of the ones we had taken in the middle of the night. I was very, very annoyed and upset by that. And because it didn't make any sense to me, I phoned the state pathologist the next day to discuss it with him. And he agreed that he would do a post-mortem with all of the information that he had. And he could tell that I was quite upset by this. So that a few days later, he phoned the ward and they got me to the phone. And he told me that all of the kids who survived had a different type of meningitis than the one that didn't. And despite the fact that I thought that I knew quite a lot about meningitis, I didn't know that meningitis occurs in these mini outbreaks from time to time, and that it often involves different subtypes of the bacteria, Neisseria meningitidis, and that some of the serotypes can be more lethal than others. I discussed it with the pathologist as to whether it would have made a difference if I had used a different antibiotic in this particular child. And he said, it may have, but why would you have done that? Because in those days, it took at least 2 days to get a classification of the subtypes, and there was no reason to look for one. That wasn't much consolation to me. He also recommended that we contact public health, which was a very small part of the NHS in those days, and ask them to do swabs on other kids that were in the same class as the patients we had, and they found quite a lot of them with meningococcus of the 2 subtypes, but none of them developed any disease. But by following method, I was able to save the lives, probably, of some of those kids. And the post-mortem method of diagnosis of death was able to explain to me what had happened. Without post-mortem input, I would still be none the wiser. The parents would still be none the wiser. And because of the advice given to me by the pathologist, I was able to head off any illness in the other kids. It's not related to the Lucy Letby trial, but it is related to methodology and following the process and having a systematic approach to diagnosis and management of disease. And another case that happened to me in that same hospital, I was helping out one day in accident and emergency, and a young lady came in with a very minor fracture of the tibia, one of the long bones in the lower leg. And this didn't require any specific pinning or stabilization, so I just put the cast on myself. And while I was putting the cast on, I noticed a strange and unusual papule on the leg. So that's like a smooth, raised, small patch of skin, a bit like a wart, but not like a wart. And I asked the girl when she had noticed this, or had she noticed this, And she said that she had noticed it. It had only come up recently on her and she wasn't bothered by it. But for some reason or other, I didn't like the look of it. And for the life of me, I don't know why. I discussed it with her. I told her what my feelings were, and she consented to me removing it because it wasn't really going to leave much of a scar. And I duly sent it off for pathology report, which came back about a week later to tell me that it was an amelanotic melanoma. In other words, it was a malignant melanoma, a lethal skin cancer that didn't develop melanin within the structure of the tumour. And unknown to me at the time, but as a result of this, I went and checked the literature. And these amelanotic melanomas constitute about 15% of melanomas, something I didn't know. And since it was only 4 millimeters deep, she came back, had a wider excision and some investigations, and the total tumour was removed. Otherwise, she would have died. And from that day on, I've never distrusted any interpretation I made of any skin wart. And I have removed them all, sent them for pathology, and found many melanotic and amelanotic skin cancers. That's the importance of methodology, and overall risk management in the practice of medicine. And even though these are unusual stories, they're not that unusual in medicine. And I would ask people to think about them in the context of this evidence. There isn't any methodology to the Dowie-Evans or embolism theory. It's just plucked out of his head. And I ask you to think, where would all of those other people, the kids who had the meningitis and the girl who had the amelanotic melanoma, where would they be if I practiced medicine and if everyone practiced medicine the same way as Dowie-Evans? Dead is where they would be. And given that I'm alive and these people were younger than me, they are likely alive too. And therefore, for me, I can't let this go. I didn't spend a lifetime in medicine learning so many things to see them chucked into a dumpster fire of ignorance by people like Evans. So we'll end the podcast here and we'll get back to finishing off and working our way through this Court of Appeal judgment on Lucy Letby. So I'll see you in the next episode. Bye.